the matter of Republic of India and Ras Al Khaimah Investment Authority.
Thank you, my Lord. My Lord, RAKIA submits that this appeal should be dismissed for the reasons given in our skeleton argument. It contends that the judge was correct to conclude that the tribunal had jurisdiction over RAKIA's complaints under Article 10 of the treaty, and that India's arguments to the contrary are subject to what we respectfully submit to be 6 significant and recurring flaws. First, they involve a misreading of the judge's judgment. They misunderstand what he found to be RAKIA's investment. They misunderstand how he approached the issue of what was applied directly to that investment. And they fail adequately to confront the particular factual context of this case, which the judge carefully set out and emphasized. Secondly, they involve a rewriting of the words used in the treaty, inserting notions of legal application and specificity of application against assets which are not present. Thirdly, they involve an unjustified invocation of principles of customary international law from the diplomatic protection context and their deployment in the quite different investment treaty context. Fourthly, they involve an inherent circularity by asserting that the exercise of interpretation to be undertaken by the court has to start with an acknowledgement that the arbitral offer is particularly and unusually narrow, when that is precisely what is in issue. Fifthly, they would, if accepted, in practice, mean that for no apparent reason, a major, perhaps the major form of investment structure would be very substantially outside the treaty's scope in terms of investor-state arbitration. That outcome, we say, would do little to serve the object and purpose of the treaty or the context provided by its other provisions. And as to those questions of object and purpose and treaty context, we rely not only on the investment treaty context generally, but also on the preambles, the reference to shareholding in Article 112, Article 3.2, which expressly obliges the parties to encourage the incorporation of and so shareholding in local entities to develop investment projects, and what we say is the proper reading of each of Articles 7.1, 7.3 and 7.4 of the treaty. And sixthly and finally, on recurring flaws, India's attempt to bridge the gap between what we submit to be an obviously common sense commercial landing point where jurisdiction applies and its case, and to make up ground on object and purpose by recourse to Article 32 of the Vienna Convention, cannot prosper. For all the reasons I will seek to develop in due course, and which were to some extent highlighted yesterday, we are a long way from confirmation territory so as to give life to Article 32. But in any event, the materials deployed are not properly admissible for the task, as they do not on their face purport to say anything at all about common intention. And even setting aside their unilateral nature, their substance tells you nothing at all about the meaning of the key words here, investment and applied directly. So against that background, my lords, we make 2 primary submissions. First, the judge correctly held that RAKIA's investment in India, within the meaning of Article 1 of the treaty, included its shareholding in ANRAK as invested in India. Secondly, he also correctly held that binding action attributable to India had been applied directly to that investment, because of its direct application to the project and to the bauxite supply agreement, the BSA. That meant, in turn, that the action constituted a measure within the meaning of Article 10.2 and Article 1.8 of the treaty. And that was particularly so, we say, having regard to the very particular factual context of this case, involving, as it did, the creation of ANRAK by RAKIA as a special purpose vehicle for the sole purpose of development of the Andhra Pradesh project, including within it the promise from the outset of Andhra Pradesh bauxite. Without that project and without that promise, neither ANRAK nor RAKIA's shareholding in it would ever have come into existence. In those circumstances, we say, on any ordinary meaning of the words, what was applied directly to the project and to the promise was necessarily also applied directly to the investment. And that conclusion is only reinforced by the requirements of good faith, treaty context, and treaty object and purpose that I'll come to. Now, if the judge was correct on those 2 points, that of course disposes of the appeal. Ground 1 of the appeal would fall away because India accepts that RAKIA's shareholding in ANRAK was an investment, and ground 2 would fail for the reasons I've sought to summarise. As explained, however, in our Respondent's notice and in our skeleton argument, RAKIA also makes 3 alternative submissions, leading to the same conclusion that the tribunal had jurisdiction under the treaty in respect of RAKIA's claims. The first alternative submission is very much in the same vein as, and with the grain of, the judge's approach to the words applied directly. By this submission, set out in our Respondent's notice ground 2 and in our skeleton at paragraph 49, RAKIA contends that the words applied directly to simply connote a direct nexus between a given action on the one hand and the value of an investment on the other. And there was, we say, manifestly such a direct nexus here because of the particular context in which RAKIA's shareholding came to exist and to be held, and because of the inevitable immediate impact on its value of the executive action in issue. The only value to RAKIA's shareholding, as the project was envisaged and at the time the investment was made, lay in ANRAK's intended interest in the plant and smelter and in its exclusive access to the Andhra Pradesh bauxite, which it was to exploit. The second alternative submission is that RAKIA's investment can itself also be interpreted as embracing ANRAK's rights under the BSA, and this is ground 1 in the Respondent's notice. If that submission is correct, then jurisdiction must also follow because it is common ground that binding action attributable to India was indeed applied directly to the rights under the BSA. And the third alternative submission is that in any event, on its proper interpretation, the arbitral offer in this treaty is located only in Articles 10.4 and 10.5 of the treaty, so that for jurisdiction to be made out, it is only necessary to show a dispute between an investor and contracting party in relation to an investment, and by reference to one of the substantive rights of protection identified. And it's not, in particular, necessary to show as a jurisdictional requirement that any action complained of has been applied directly to an investment. And that last argument as to the true scope of the arbitral offer, as the court knows, was pursued before the tribunal, but not pursued before the judge, and it's accepted that permission is required to advance it. My lords, in terms of division of argument, I'm going to address the court, if I may, on why RAKIA says the judge was right for the reasons he gave, and by reference to the 2 primary submissions I've just described, as well as the complementary, as we would put it, Respondent's notice ground 2 on the meaning of applied directly. And Mr. Juratovich will then advance Respondent's notice grounds 1 and 3 relating to the BSA being part of the covered investment, and to Article 10 and the scope of the arbitral offer, as well as the question of permission in that latter regard. Before, though, turning, my lords, to the judge's approach specifically to the issue of investment and the meaning of applied directly, I would like to start, if I may, by emphasising the importance and correctness of what he had to say about the factual background. Because, as I've already indicated, it is, we say, critical to have that firmly in mind from the outset and at each stage of the argument. Now, this was set out in some detail by the judge at paragraphs 14 through to 41 of his judgment in the bundle beginning at page 105. And it's also...
Mr. Audley, just before you go on to
yes,
that, just on the structure of your argument, on what you call your two primary submissions. Yes. As I understand it, this is on the footing that the investment is in the shares.
Yes.
So your second submission then is that applied directly means that the measure applied directly to the shares.
Yes.
The way you just expressed it, you moved into the project and the underlying,
yes.
As it were, the underlying facts.
Project
your submission has to be that it applies directly to the shares.
Yes.
Is that right?
That is right, my lord, on this primary submission. And the reason for that is because it definitely applied to the project and it definitely applied to the BSA. And once you have a proper regard for this particular factual context, special purpose vehicle, sole purpose, etc., etc., it necessarily follows that it applied directly to the shareholding on any ordinary meaning approach. And we respectfully adopt and embrace what we would submit to be the analogous situation posited by my Lord Justice Phillips yesterday in relation to the cash and the loan and so forth. On any ordinary meaning, there is direct application.
Right, thank you.
Can I also just clarify, and from the way you've expressed it, there's nothing between the parties on what has been argued as ground one. They say the investment of the shares, and you agree.
Yes, the only issue that's between us on ground one, my lord, is that as ground one is articulated, India says that isn't what the judge found. India says what the judge found in terms of the investment was that it was the project was the investment. And they rely on...
That may be so, but
yes, I'm sorry.
But you and they are agreed on this appeal.
I'm sorry, my lord.
You are agreed, the two sides are agreed on this appeal that the investment is the shares.
Yes, my lord, we are agreed on that.
Yes. So whether or not that's what the judge found, you're agreed.
Yes, my lord. The point I'm making is that the criticism of the judge in ground one is that he got the wrong investment, and then he therefore went wrong also on the second stage, what was applied directly to what.
Yes.
And we say it's absolutely clear that the judge was carefully and precisely identifying the investment as the shareholding. And he then comes on to answer the critical question, which my lord's absolutely right, is the really live issue in the case. What was applied directly to that investment?
Well, we heard almost a morning's argument yesterday as to what was the investment.
Yes.
And the conclusion of that morning's argument is the investment is the shares. And you stood up today and said the investment is the shares.
Yes, my lord.
That seems to me to be...
It's only ground one of our respondents' notice.
Unfortunate.
I'm sorry, my lord.
That seems to have been unfortunate.
Well, we've made it quite clear in our skeleton, my lord, that we've said the judge found the investment was the shares. We understood Mr. Wordsworth yesterday really primarily to be devoting his argument on the question of investment to our respondent's notice ground one, namely whether ANRAK's assets can fall within the term investment. And that will be developed by Mr. Juratovic in due course.
Yes, I see.
But my point at this stage of the argument is that to do justice to the judge's approach, one needs to start with looking at what he actually found. And he actually found, quite clearly, the investment was the shareholding. And once you've understood that, you then look at paragraphs 110 to 112, particularly 111, 111, and you see that he is concluding that there was direct application to that investment, the shareholding, in that, because, we would say, there was direct application to the project and to the BSA.
Well, he says very clearly that an investment has to be assets.
Yes.
And that's very clear.
Yes.
What he says later on is a little less clear.
Yes.
Is it fair to say that?
Well, I'm going to... I take that point, my lord, yes. But I will say, read in context, particularly when we've looked at the whole factual background, it's very clear what he's saying. And he was right.
I think when you outlined your submission, it was that the investment included the shares.
Yes.
The judge went further.
Cash and
Perhaps
pledge.
that's why you say it, and said the cash and the pledge. I think we established with Mr. Wordsworth yesterday that so far as he's concerned, it doesn't really matter whether the judge was right or wrong to add those extra points. Do you say that that makes any difference?
It doesn't make any difference, my lord, no. We've got a bit of extra factual detail on the pledge to give, which provides a bit of extra context and further illustrates how bound up everything was and how inextricable everything was, which then feeds into the applied directly.
So as far as Mr. Wordsworth is concerned, his case is that the investment is limited to the shares, and so far as your case, leave aside what Mr. Duratovich is going to say, you're content with that?
I can live with that, my lord, yes, absolutely, yes.
Right, okay, well, that seems to simplify some aspect of what we're dealing with.
Yes, it does, my lord, it does. Can I go briefly through the factual background, because it does provide, we say, highly material context to the key question, which I'll get to, and I'll take the cue from the court to put the foot down when I'm dealing with the question of investment, but I'll deal with it in deference to the judge, if I may, because it's important to see his whole chain of reasoning across the judgment.
Yes, very good.
So, as I say, it's 14 to 41 of the judgment, and for the court's reference, we picked up the key points, I think, in paragraphs 34 and 47 of our skeleton as well. And there are 6 interrelated points in terms of the factual background that I wanted to emphasise, if I may. The first, which comes from paragraphs 15 to 18 of the judgment, and which is referenced in our skeleton at 34.1 and 47.1, is that the local Andhra Pradesh bauxite, which would ultimately be the subject of the BSA, was absolutely integral to the project with which ANRAK was to be concerned from the outset. That is evident from the repeat references to those local bauxite deposits in each of the recitals to the MOU between RAKIA and the government of Andhra Pradesh, underpinning the project and explaining Ras Al Khaimah's central role in establishing a plant where it intended to and to exploit those resources. As I say, that's apparent from what you see in paragraphs 15 through to 18. So 15, you have the decision to establish the industry in the state of Andhra Pradesh. 16, you have the importance reference of the government of Andhra Pradesh having reserved the entire deposit-bearing areas for exclusive exploitation. 17, you have the first recital referencing the ability of a state-owned corporation to mine these areas. And in the last line, the desire to produce end products based on these valuables mined by APMDC.
The point you're making now, I think, slightly ties in with what I understood was going to be argued, but I think in the end wasn't, namely the second part of ground 2, the factual criticism of the judge, which I'd understood was going to be argued yesterday, but I don't think was in the end.
the end, the project.
Yes.
Yes, my lord. It does go to that to some extent, and we say the judge was exactly right to express himself in the way he did, because what happened as a result of this executive action was undoubtedly to end the project as originally envisaged.
I did wonder what happened to that, because Mr. Wordsworth said that Mr.
Dar was going to deal with it.
He didn't. So I presume that's been abandoned now.
Yes, it doesn't. We say nothing actually turns on that issue in any event. As the judge found in his judgment, what matters was what the position was at the time of the action in terms of jurisdiction. Whether or not something has managed to be salvaged because of access to alternative bauxite thereafter doesn't alter the question, as at that point, whether the jurisdictional hurdles have been cleared. So it may be that's why it wasn't developed.
The thing is, you may well be keen to build a refinery and smelter because you've got local bauxite, but
yes,
that doesn't mean that you couldn't run a refinery and smelter on imported bauxite.
As a general proposition of logic, of course, that's right, my lord. The point of going to these documents is that it was absolutely foundational to this project that it was all about the local bauxite. And once you appreciate that, and once you emphasise that, as the judge did, we say, properly and fairly reading his judgment, the direct application question becomes very easy to answer and answer in our favour.
I suppose whether you could use imported bauxite might depend on such questions as whether there is the infrastructure in terms of a suitable importing port and facilities to get it to you. And I'm afraid I don't know enough about the geography of India to know where Andhra Pradesh is, I'm afraid, or what ports might be in that area.
My lord's absolutely right to raise it as a hypothesis, and all of that was very much an issue at the arbitration. The award doesn't reach that question because of the question of jurisdiction. But India's case was, well, it doesn't matter too much. There's alternative bauxite you can get from Australia, Guinea, elsewhere. Our point, which is what matters in terms of interpretation and consideration of the judge's conclusion on applied directly, is what was the project envisaged at from the outset when this shareholding was created, so that we can answer the question, what was applied directly to this shareholding? And that's why it's important to look at all of the foundational documents, the MOU, the bauxite supply agreement, the shareholders agreement in relation to the shareholders in ANRAK, and all of that speaks with one voice. This is all about a project to exploit these particular reserves of bauxite. And that is why, again, it's unsurprising, but in evidence before the tribunal, that's why the decision is made to build the plant and the smelter there, because of the access to this bauxite. You don't spend $1 billion on building a plant unless you know where you're going to get the material from. And that was what was envisaged on day one, as all of these documents show. And as I say, the fact that it might or might not be possible to salvage something by reference to alternative bauxite doesn't matter for the purposes of the jurisdictional issue in this appeal, because the key issue for this court, in the end, subject to the respondent's notice grounds, is what was applied directly to this shareholding. And if, in context, it's inevitable that application of a binding action to the project, to the supply of bauxite, impacts on, we would say, destroys the original project, that's application direct to the shareholding, just as seizure of the cash in the bank account hypothesised by Lord Justice Phillips yesterday is direct application to the loan. And it's no answer to say, oh, you're fine, you've still got that piece of paper, you've still got the promissory note, or you've still got the share certificate. And again, it builds on I think the first observation that my Lord Justice Mayles made yesterday. This shareholding derives its value from this plant and smelter and this access, exclusive access to bauxite. And it necessarily follows, as a matter of ordinary meaning, common sense, we would say, evident in common intention, that there's direct application to the shareholding. And as I say, that's then reinforced by all of the additional Vienna Convention criteria that we'll need to look at. So I'm not really getting very far over the first couple of fences on factual context, but it's very helpful for me to have the opportunity to say why I say it matters. Mr. Dar's got a point he wants to make.
My Lords, I apologise for interrupting, just in relation to my Lord Justice Phillips's observation in relation to the factual appeal. I didn't mean to give the impression that it had been abandoned. It's only a short point in our skeleton argument, which we do still rely upon in relation to what the judge found at paragraph 111. It's correct that I didn't develop that point yesterday, but we rest on what we said in the skeleton on that point, my Lord. So it wasn't formally abandoned, just to be clear.
Thank you.
So, my Lord, first point, just to recap again, 15 to 18 of the judgment. Local Andhra Pradesh bauxite, which would ultimately be the subject of the BSA, was integral to the entire project with which ANRAK was concerned from the outset. And that's evident from the repeat references to those local bauxite deposits in each of the recitals to the MOU that we see set out at 15 to 18. Secondly, and this is judgment paragraph 20, skeleton 34.2 and 47.2. Secondly, under the terms of the MOU, Ras Al Khaimah, the Emirate, RAKIA, and their associates were to incorporate an Indian company, a special purpose vehicle, with one goal: to set up the aluminium refinery and smelter at specific locations in Andhra Pradesh so as to be able to access that bauxite. And that incorporation of an Indian company was the very first step envisaged by the MOU. And as I've already said, this form of investment was also one of those specifically encouraged and envisaged by this treaty at Article 3.2 of the treaty. And just to make the point while it's there, this may in part be an answer to the point raised by my Lord Justice Miles yesterday, when he was cautioning against the potential risk of focusing too closely on a shareholding when it was only one of a series of investments and assets listed in Article 1. We have incorporation of a local entity singled out in Article 3.2 as something the parties are obliged to encourage. So that's the second point. Third point, under the MOU, the Government of Andhra Pradesh, and this is again judgment paragraph 20, MOU recital 3, our skeleton 34.1. Under the MOU, the Government of Andhra Pradesh would provide for the supply of local bauxite on an exclusive basis to that company that RAKIA was to incorporate, namely ANRAK. Fourthly, this is judgment paragraph 21, the supply of bauxite would be regulated by an agreement between a Government of Andhra Pradesh owned company, APMDC, and that company ANRAK. That's our skeleton 34.3. And fifthly, unsurprisingly, against that background, ANRAK was duly incorporated, as the MOU had anticipated, and its shareholder agreement expressly described its purpose as being to set up an alumina and aluminium smelter using the bauxite from the Jarala mines. That's judgment paragraphs 23 to 25 and judgment paragraph 26, and is referenced in our skeleton at 34.2. And that again is an important factor to have in mind, perhaps in response to my Lord Justice Mayall's point, that as a matter of theory, and indeed Lord Justice Phillips' point, as a matter of theory, it might well be possible to have a plant which can get bauxite from all sorts of different places. But what we know in this particular context is that the shareholder agreement relating to ANRAK and every other document was focused on exclusive supply of local bauxite, and that being the bauxite to be used by the smelter. And sixthly then, relatedly, and this is judgment 35, 38 and 41, and our skeleton 34.3 to 34.4. Sixthly, ANRAK and APMDC then entered into the BSA, whereby APMDC agreed to the supply to ANRAK of the local bauxite for the lifetime of the plant, again illustrating how bound up everything was. It wasn't just for the first couple of years until you can get yourself off the ground and source bauxite from elsewhere. It was for the lifetime of the plant or until exhaustion of the bauxite mining reserves. And ANRAK, for its part, in turn agreed to purchase the bauxite and to develop all infrastructure necessary, back to the point raised by my Lord Justice Nails, necessary to transport the bauxite from the mines, from the local mines, to the plant. So at every turn, from every perspective, this was about exploitation of this local bauxite. And so this was not a case of RAKIA simply buying shares in an Indian company. And it was not a case involving an Indian company with a range of different activities. It was instead a case of an Indian company being incorporated by RAKIA for a single and very specific purpose, contemplated by the MOU signed with India, the development of this particular project using this material in Andhra Pradesh. And as I say, without that project, neither ANRAK nor RAKIA's shareholding, its investment, would have existed at all. And as we've seen, the absolute cornerstone of that project was to be a contractual entitlement to exclusive access to local bauxite supply. So all of these matters, my lords, we say were intertwined and dependent on each other from the outset.
There's quite a gap between what was suggested in the MOU and what actually happens on the ground, isn't there? I mean, I can see this is part of the history, but the MOU talked about your clients setting up the company, incorporating the company, and it looked on the face of it as if they were talking about a capital outlay. You might think it was your client's investment of $2 billion.
Yes, my lord.
US dollars. And in fact, what happens is that a company is set up in which your client has a minority shareholding and puts in 40 million or something like that.
Yes, my lord.
And it's heavily leveraged, as I understand it.
It is, my lord, and this was a point made yesterday to rather criticise and downplay RAKIA's actual stake in the game.
I'm not sure it's really about that. I mean, maybe it's a criticism, but it's more that one can see that things very much moved on, and I just wonder how right you are to be suggesting that somehow one goes back to what's said in 2007 rather than looking at what actually happens on the ground.
2 points, my lord. One, in terms of what is material, nothing has moved on. On day one, it's all about exploitation of the local bauxite. On day one, it's only through the incorporation of an Indian company that this project will get off the ground. On day one, it is only envisaged that that Indian company will have exclusive access to that bauxite. So nothing material has changed in terms of the cornerstone of the project and the raison d'etre of ANRAK's existence and RAKIA's shareholding in it. My lord rightly observes the difference between the contemplation of a 2 billion investment and the 42 million for the minority stake. As to that, that may be where the extra little bit of detail I was going to provide in relation to the pledge context bridges that gap, at least in substance to some extent, because the effect of RAKIA pledging 100% of its shares was to release $650 million in bank financing for the project. So RAKIA was still absolutely integral in the financing of this project.
Did the other company pledge its shares?
I don't know, I'm afraid, the answer to that question.
Appellant
APMDC.
Industries.
I don't know, my lord. I'll have to check that, I'm afraid. But in terms of
On the face of it, just looking at those numbers you've just described,
there's still 1.3 billion left, my lord, yes. But there's a very substantial... The point was made yesterday, this was all built as a result of bank financing. And that's true, but it's bank financing that was founded centrally to a very substantial extent on RAKIA pledging 100% of its shares. So one can't...
But that goes round in a circle with respect, because the value of the shares depends on the injection of funding from the banks. And it's not as though the shares independently suddenly, which you put in 40 million, the shares don't magically become worth hundreds of millions. The financing is the financing of the project, and that then, no doubt, is ultimately reflected in the value of the shares.
I accept that, my lord. And my point is simply as a way of to refer to that as another way of illustrating how interlinked everything was. The shares were integral to the pledge was integral to the financing. You can't sever these things off or silo them. And it's all of a piece with the overall picture that the key elements, location of the smelter in Andhra Pradesh, exclusive access to bauxite supply, were integral to ANRAK's existence and to the existence of this shareholding. And so it's very different, as I say, to investment in any old Indian company that might be pre-existing. It's very different to investment in an Indian company with a range of different activities and purposes. It's investment in a company with this specific purpose for which it would never have existed. And what hasn't changed, and I apologise for repeating it, but I respectfully submit it to be important. What hasn't changed at any point is that the cornerstone of the project is exclusive access to bauxite supply. And if you cut away that, you remove that cornerstone, you inevitably directly apply your conduct to everything else. And certainly that was the judge's approach, as we'll see, to emphasise that context and to distinguish the position from a case where there's simply purchase of an ordinary shareholding. And that's key to what we submit to be the correct approach to the concept of applied directly.
If you just buy an ordinary shareholding, you just buy shares in a company, that wouldn't be an investment, would it?
I'm sorry, Molly,
if you just bought shares, that wouldn't be an investment, would it?
No. And that's the critical distinction that's being made here, is that there is an asset as invested in this project. What's this project? It's a smelter and a plant in Andhra Pradesh. What's the detail of that project? Why is it there? Because of the local bauxite. It's all bound up.
One can see that if you have, if you are the sole shareholder in the SPV, or a very substantial majority shareholder, I can see the argument then that, well, if you take measures which directly undermine the business of the SPV, then you are directly applying them to the shareholding in the SPV. But once you become a minority or increasingly small shareholder, then that argument becomes increasingly difficult, doesn't it? To say that the action is directly applicable to the small minority shareholding. It may be applicable to the company then, but then there is then a question, isn't there, as to whether or not it's directly applicable to a minority shareholding.
there is a question, my lord. We would say it doesn't become more difficult in a particular context such as this, where that minority shareholding only ever existed because of this project. It's exactly the same. It doesn't matter that, to go to my lord's example, some cash might be owed in one direction, some cash might be owed in a different direction. What matters here is that this shareholding only came into existence because of this project. This project had at its heart the bauxite supply, and once you cut away the bauxite supply and you definitely apply something directly to that, and once you definitely directly apply something to the project, you have definitely also, we say, directly applied something to the shareholding in this particular context. And the minority-majority point doesn't matter at all, we would say. The material point is, why did this shareholding exist? Why is it an investment? And that is all inextricably linked to the project and the bauxite supply.
In those circumstances, is the measure applied directly to all of the shares
Yes.
in the company, or simply to the RAKIA shares, which, as we know, happen to be a small minority?
It would be directly applied to all of the shares in the company, but the Indian company, APMDC, wouldn't have a remedy under this treaty because it's not a foreign entity. But yes. And then the compensation question is referable to the extent of the shareholding. And that's where it becomes relevant. But it isn't relevant on this question of direct application. Obviously, there's a whole separate debate which Mr. Juratovich will develop in due course as to how the majority-minority dynamic plays out in terms of what you're actually characterising as an investment. Can you characterise ANRAK's assets as an investment? But on this question of pure direct application, ordinary meaning, we say, says it's direct application to all three things: project, BSA, shareholdings. And I'll, as I say, develop in due course why that's also so once one goes through the other Vienna Convention criteria of good faith interpretation, treaty context, object and purpose as illustrated by the treaty. But it all points in the same direction. So that was what I was going to say about why the facts mattered. And I was then going to go, and taking the cue from the interventions earlier, I was going to go to the question of the judge's actual conclusion on RAKIA's investment.
Yes.
And this is addressed in India's skeleton argument at 23 to 58, and in our skeleton argument at 23 to 29. And as you'll have seen from the skeleton argument, where it was only touched upon quite lightly yesterday, India contends that the judge erred in its ground one in finding that RAKIA's investment was the proposed establishment of an aluminium and alumina industry in Andhra Pradesh. And then there's the cash and pledge point, which doesn't really matter. And we submit that on a proper reading of the judgment, that's simply not what he did. A series of passages in his judgment make it abundantly clear that or at least a key investment on the part of RAKIA, which the judge was identifying for the purposes of his conclusion that jurisdiction was established, was its shareholding in ANRAK as invested. And he addresses this question at paragraphs 77 to 94 of his judgment, unsurprisingly under the heading investment by RAKIA. So 77 to 80, he sets out the material terms of the treaty and some of the issues they gave rise to. 78, he set out the definition of investment from Article 1.1 of the treaty as concerning assets invested in the territory of the other contracting party, not, for example, simply assets owned or controlled by the investor and located in the other contracting party. And at 80, he then notes that the question which lies ahead is whether there's been application of a measure to an investment. 81 to 83 then set out some of the argument to date as matters stood before him and the content of the underlying MOU between the Government of Andhra Pradesh and RAKIA, which, as we've already seen, the judge had taken care to set out in detail at paragraph 20 and following of his judgment. And in line with those earlier passages, as paragraph 83 then indicates, as I've submitted, the two central components of the entire project from the outset were first that RAKIA would set up ANRAK, the Indian company, through which the parties agreed RAKIA would invest, and secondly that Andhra Pradesh would procure the exclusive supply of the local bauxite under what would become the BSA. Now, none of that's controversial, and it's at least a partial record of both the treaty and the argument and of the factual background. And paragraph 84 then identifies the first material question, namely what asset did RAKIA invest in India? And the second sentence of paragraph 85 is explicit in providing the judge's answer. The judge states the basic answer to the question is it invested $42.5 million, the shares and the pledge of shares in the territory of Andhra Pradesh. Paragraph 86 then contains precisely the same focus on RAKIA's shares as its investment, either in and of themselves or as a change in form from the cash advanced. And paragraph 87 then explains the judge's reasoning as to why the pledge involved an investment. And it was investing the shares by allowing a pledge over them and so forth. And none of that really matters to the issues before the court. And I've already given the extra bit of detail about what the pledge did in terms of providing financing. The reference to that in the bundles is Bradfield 1, paragraph 56 at Supplementary Bundle 73. Paragraph 88, the judge states again he did not consider that any of the cash shares or pledge can be treated other than as an investment. And the tribunal was, he said, right to say that RAKIA's shares in ANRAK were an investment in India. So again, the shares are absolutely centre stage as an investment in his reasoning.
Although the judge is going further than the tribunal, who say at paragraph 134 that the investment is the shares and nothing but the shares.
Yes.
But you say
doesn't matter.
The ancillary bits don't matter.
Doesn't matter. The only additional point we say we get, which is not without significance, is to put a bit of colour on what the pledge was doing, to show how everything was bound up together.
Well, as I understand what the judge says is that invested 42.5 million. That's absolutely right. They did invest 40.
Yes.
Then it was converted into shares.
Yes.
Which he deals with in 86.
Yes.
And he says there's no double counting. And that seems to be clear cut.
Yes.
So there was cash, it becomes shares.
Yes.
And then he says, well, you then pledge the shares. Now he says that's investing the shares, but it's probably right to say it's investing the value of the shares to the extent of their pledge.
Yes.
None of that seems to be controversial.
No, my lord, it isn't.
So, and the conclusion is at 90, isn't it?
The conclusion's at 90, exactly, my lord, where he rejects, essentially, the argument that he set out at paragraph 89. Paragraph 89 references RAKIA's descriptions of its investment as in the project as a whole and the operation of the project as well as its component parts. And then at 90, he says that those descriptions merely provide a characterization that helps confirm that the assets invested were investments. And he then says in terms that these descriptions do not add to what the assets invested were. So again, for his part, he's being entirely clear as to what he considers the investment to be. And for our purposes, so far as it's material, it's the shareholding as invested.
So you say that having said at 89 and 90 that the investment is not in the project as a whole, it is unlikely that he intended to say the opposite in paragraph 111.
Yes, my lord. There are a number of other points in the judgment which make that even clearer. And I'll come to them. Because that's, my lord's right, it's 111 that India relies on to say he took a wrong turn at this point, and that's the foundation of their ground one.
Yes.
But it just doesn't work when you look at what the judge actually says in the section headed investment by RAKIA and also in the later sections. And that 91 to 92, that's confirmed, where the judge sets out his approach more fully and identifies the relevance of a holistic approach as in defining whether a particular asset was an investment, rather than in broadening out what was an investment. So he states in terms that the holistic approach doesn't involve treating as an investment something that is not an asset, and he's taking exactly the same approach as Mr. Justice Foxton did, which he refers to. 93 to 94, he makes the point, not every purchase of shares in a company incorporated in India would be an investment under the BIT, the point my lord asked me about earlier. But he says that quality as an investment could be readily seen, that quality of those shares as an investment could be readily seen in the present case because the incorporation of ANRAK and the shareholding in it were the modality by which RAKIA invested money in the project the MOU had described and begun. So again, emphasising, we say correctly, how integral and intertwined bauxite supply, shareholding and everything else was from the outset.
Well, I wonder if it's actually quite helpful because it's accepted that just buying shares from another shareholder isn't an investment. All you've done is bought the shares. So holding shares isn't per se an investment.
Yes.
So what is it that's the investment then? It's the fact that you have put assets, usually money, into something.
Yes.
That's the investment. So here, the investment is the 42 million, which is then represented by an asset, which is the shares.
Yes.
But the shareholding in itself isn't an investment.
You can't conclude from the fact of a shareholding that there is an investment. In order to determine whether the shareholding is an investment, you need to take what's described correctly as the holistic approach of looking at the wider picture to see why the shareholding came into existence, what it's helping to achieve, what risk might be attached to it, what the purpose was, and so forth. And all of those factors help characterize that shareholding as an investment. That's what's going on here, and that's exactly the judge's approach. And with respect, it's not really in dispute between us, but it's my lord says, it's a helpful illustration of how these different pieces fit together. But it's all of a piece with the way we also present our broader case when we get to the question of applied directly, that all of these aspects of this project were interlinked and interdependent and conceived as such from the outset. And it's quite unreal, even before we get to treaty context, object and purpose, to take such a narrow view of applied directly, to say, oh no, it can only apply to the paper shareholding certificate in a context such as this. It definitely applied to the shareholding, and we say in context it definitely applied directly to the shareholding just as much as it did to the project and the BSA. But in any event, for the purposes of just explaining the judge's conclusion and disposing of ground one, it couldn't be clearer that the judge's focus in terms of RAKIA's investment was on cash, shares and pledge. And for our purposes, as I say, it's shares that really is sufficient.
Can I just see if I can understand this argument? So what under the agreement, under the treaty, the definition of an investment is every kind of asset invested by the investor in the territory.
Yes.
And one can regard in this case, this is your argument, I think, the 43 million was put into the project. Other steps are taken, like the pledge. It also says that any change in the form in which assets are invested doesn't change their character as investment. And essentially, as I understand it, you're saying that yes, they end up as shares. That's the form in which the investment is, or by which the investment is represented.
Yes.
But it remains the case that it's an asset invested by the investor.
Yes. And furthermore...
But you wouldn't be able to say, you could, going to the judge's double counting point, you couldn't say, well, I've both got a cash investment and a share. Once the shares are issued...
There's been a change of form.
There's been a change of form.
Yes, my lord. But the judge was right.
So it's been landing on that the investment is for shares.
We are, my lord. We are. I'm sorry to have taken time on something that's essentially agreed, but it's important, as I've said, to have this firmly in mind once one gets to the question of applied directly, because of the way the judge approaches it, and the important distinction between this particular shareholding, the modality by which this project got off the ground, and any old ordinary shareholding. And once you have that sufficiently firmly in mind, applied directly becomes entirely straightforward, we say. And then
holding shares in an Indian company, the judge's point, is not a sufficient condition to make it an investment.
No.
But on the other hand, holding shares in an Indian company may be an investment depending on the circumstances.
Yes, if in context it's properly to be treated as invested in India. Because 1.1 and the definition of investment doesn't speak about ownership and control of assets. It talks about a list of assets which are invested in the host state, and those are the investments. And you then end up answering the question, what is applied directly to assets as invested, to assets qua investments? And once you feed in characterizations like the shareholding was the modality through which RAKIA invested in the project, once you properly confront the fact the shareholding would never have existed without the project and without its component parts, including bauxite supply, as I say, even at first base of the Vienna Convention approach, good faith, ordinary meaning, we say you get to a position where there's application directly to the investment.
This is slightly tying us all the knots over this.
I'm sorry, my lord.
The investment is the 43 million that you put in. That is then held, the way you hold that investment is through the shares.
Yes. But the shareholding is the investment in the end, because there's been a change of form into it.
It's changed into shares, but there's no doubt that your investment is the money you put in. And that's why you talk about a return on your investment.
Yes, my lord.
And if I hold shares in a foreign company, I can sit in London with holding shares in a foreign company, but I haven't invested in it. The way that I become an investor under a BIT is by classically putting money in.
Yes, you need to look at questions of contribution, what you put in. You need to look at questions of duration, what's intended by that putting of money in. You need to look at questions of risk to see whether you are in truth an investor who has invested their asset rather than simply someone, the day trader example my lord gave yesterday, who's got no particular commitment to a jurisdiction, let alone a particular project in that jurisdiction. And that this is the other end of that spectrum, and very clearly an investment. That's no doubt.
The BIT in a way uses investment in two senses, doesn't it? Because in any ordinary use of language, what you invest in is the money that you put in.
Yes.
But BIT also talks about protecting the investments, and by the time it's talking about that, it's talking about protecting what it is that you get for your money.
Yes, my lord. And I think my lord put it yesterday at one stage of the argument as showing there was essentially an elision between the different concepts. There was an elision between shareholding and project and so on. And that helped you see that this was an investment.
I wonder though whether you really do need the money going in bit of it for it to count as an investment, because here, supposing that your clients had bought this shareholding from somebody else, so someone else had put the money in originally, and then you stepped into their shoes.
Yes.
And so only bought the shares, I would think that might well still be an investment because of the nature of the holding.
I would
agree. The money doesn't go into the company, so one has to be quite careful about the elision point. And at the end of the day, you ended up with shares. You couldn't have gone back and said, I want my money back.
Yes, my lord. My elision point, and the reason I like elision as a concept in this context, is elision, or as we would put it, inseparability between the shareholding and the business, and the shareholding and the project, and the shareholding and the local bauxite supply, which shows that application directly to one is application directly to another. And in context, we say that that is what the right outcome is here. But that's to jump ahead to my submissions on applied directly to some extent. Just to round off the question of the judge's approach to ground one and to the investment and to the question of ground one, as I said earlier in responding to my Lord Justice Mayles, India seeks to resist that reading of the judge's judgment by reference to what he says in paragraph 111 of the judgment. And as I think I've already said, but as I'll explain in due course again, if I may, what the judge is doing at paragraph 111 is addressing and answering a different question, namely whether the binding action he had already identified, and which I'll also come to, GOM 44, was being applied directly to the investment, which again he had already identified. See paragraph 90. And that reading of the judgment is borne out by a whole raft of matters in the judgment. It's borne out by the fact that paragraph 111 appears under the heading and applied directly to an investment on the opposite page. That's the section of the judgment that he's dealing with there. It's borne out by the very clear and careful consideration of the term investment in the earlier paragraphs we've just looked at, under the heading investment by RAKIA. It's borne out by paragraph 103, where he says it helps in the present case to keep in mind that RAKIA's investment was not simply a shareholding, it was, in the manner explained above and over time, a number of things, and he then lists them: the 42.5 million, the shares, and the pledge of the shares. So again, that's the focus of what he's describing as the investment. And it's also borne out very clearly, we say, by what the judge actually says in paragraph 111. And this isn't to put a gloss on words at all. There was application to the investment, the one I've already described above, in that we would say because the action was applied to the proposed establishment of an alumina and aluminium industry in the state of Andhra Pradesh. And in GOM 44, the government acted directly to end the supply of bauxite and so forth. So he's making it absolutely clear that he's reaching the conclusion that there was direct application to the investment, and he's setting out his reasons why that is so. Now, whether his reasons are right or wrong are ground two, and I'll come to that in a moment. We obviously say they were right. And if there was any doubt at all as to the shareholdings being centre stage in the judge's consideration of what was an investment, then they're further removed by the important paragraph that I've already referenced, at least by summarising its content, paragraph 116 of the judgment, where he's addressing the consequence of India's arguments as to the term applied directly. And he says that those arguments would in practice mean that a major form of investment structure fell outside the compass of the treaty without apparent reason for that choice. And despite, we would add, despite the treaty expressly encouraging that form of investment in Article 3.2. Now that reference to a major form of investment structure can only be a reference to a shareholding in a locally incorporated company. And so it's again making it absolutely clear that that's what the judge is focusing on as the investment he has found.
What he means when he says fell outside the compass of the BIT is essentially fell outside the offer to arbitrate.
Fell outside the offer to arbitrate, the investor state offer to arbitrate, yes.
Yes, because it would still be, that's one of the points against you, it would still be part of the BIT,
yes,
the possibility of state-to-state arbitration.
Yes, he's making the substantive point, my lord, but that's what he means, I agree. Yes. So ground one just falls away because the judge has been absolutely clear what he's found the investment here is. It's the shareholding for material purposes. Which then takes me to ground two, which we've of course canvassed to some extent in the questions that the court's put to me, but is the critical question subject to the respondent's notice points and the judge's conclusions on binding action applied directly to an investment. And this issue in turn, as the court of course has seen, requires consideration of whether the judge was correct to conclude that there had been a measure underlying the dispute taken by a state government exercising executive powers within the meaning of Article 10.2 of the treaty, subject to our ground 3 and scope of arbitral offer point. And by virtue of the definition in Article 1.8, which the court has of course seen, that in turn required determination of two further sub-questions. Firstly, whether there had been any form of binding action attributable to India. And secondly, whether that binding action had been applied directly to an investment. And there's no issue about the first of those sub-questions, whether there was some form of binding action attributable to India. The judge has identified GOM 44 as binding executive action. That's paragraph 100 of the judgment, and as my Lord Justice Mayles pointed out yesterday, it's a respect in which he went further than the tribunal's assumption in that regard. But the second sub-question is of course very much an issue, and it is the issue, whether GOM 44 can be said to have been applied directly to RAKIA's investment, namely its shareholding in ANRAK as invested in India.
On the first issue, you say, I think rightly, that there is no issue, that it is binding action and it is executive action.
Yes.
But one of the points against you is that the offer to arbitrate does not extend to legislative or judicial action. Will you be, and therefore it is said it shouldn't be all that surprising if the offer to arbitrate is not coextensive with all of the rights in the BIT. Will you be dealing with that at some point?
I will, my Lord, yes. Yes, I will. The basic point on coincidence or otherwise, I'll come to it in more detail.
Come to it when you want. I just want to make sure it's somewhere on your agenda.
It's there, it's on the menu, I hope, my Lord. I won't try not to miss it. But the basic point is that, yes, it's true that substantive protections and arbitral protections don't always coincide. It's not unheard of. But, and this is the crucial point, where that is the case, it is done by clear words. And that was the authority cited to the court yesterday in this regard, I think, was EAIB. And there the clear words were that the arbitral offer extended only to questions of compensation. And there was an attempt to say, oh, well, that can't be right because of the object and purpose. And the finding of the tribunal was no, object and purpose cannot override clear words limiting the arbitral offer. Now, our point in that regard is that the undefined term applied directly is being asked to carry a huge amount of weight in that regard so as to narrow the arbitral offer in the way that's suggested by India. Now, what I'd like to do, my lords, if I may, on this applied directly and on ground 2, is address again how the judge decided the question and seek to pick up India's particular criticisms of his approach along the way, and then address what we submit ultimately is quite a limited variant on his approach reflected in our Respondent's Notice Ground 2, before returning in conclusion, and I hope not too late in the day, but in summary form, to the actual exercise this court is confronted with under the Vienna Convention, and where the different indicators point in that regard, once we've gone through the judge's judgment and the various other provisions of the treaty. Again, though, important, we say, to have firmly in mind how inextricably bound up with the supply of local bauxite and the project as a whole RAKIA's shareholding in ANRAK was. And also the correctness of what the judge had to say about the approach to interpretation of the treaty. Now, I've already addressed the factual context. So far as the approach to interpretation of the treaty is concerned, the judge set out this at paragraph 69 through to 76 of his judgment. And he started by setting out the material provisions of the Vienna Convention itself, Articles 31 and 32. And then he identified and adopted the core approach illustrated by the English authorities as embracing 3 basic points. Firstly, that although we inevitably, for the purposes of presentation of argument, break it down to some extent, what's required in the end is a single combined operation embracing all elements of Article 31 of the Vienna Convention. So a good faith interpretation in accordance with the ordinary meaning of the terms in their context and in the light of the treaty's object and purpose. Secondly, that you need an even-handed approach so that treaties are not to be interpreted either liberally, i.e. pro-investor, or restrictively, i.e. pro-state. And thirdly, that no particular deference was due to a tribunal's approach to jurisdictional questions. That's 75 to 76 of his judgment. Now, none of that's an issue in this case, but it's important, again, in doing justice to the judge, to show that he had it all firmly in mind. For the purposes of this appeal, we would add only one additional point, which is explained by Gardner in his textbook, and it is that the concept of a good faith interpretation under the Vienna Convention signifies, as Gardner puts it, an element of reasonableness qualifying the dogmatism that can result from a purely verbal analysis. And the extract from Gardner is in volume 4 of the authorities bundle at tab 54, page 1194. and you see the quotation I've just given, you see page 1195 of the bundle, page 171, just by the hole punch. Good faith means more than simply bona fides in the sense of absence of mala fides or rejection of an interpretation resulting in abuse of rights. It signifies an element of reasonableness qualifying the dogmatism that can result from purely verbal analysis. As discussed above, the term is also capable of a sufficiently broad meaning to include the principle of effective interpretation. And then in similar vein, over the page, just below the top hole punch, in its specific application to the interpretation of treaties in Article 31, Oppenheim's international law notes that the concept of good faith strongly implies an element of reasonableness, and that the requirement that a treaty is to be interpreted in good faith as well as being necessary as a matter of general principle follows from Article 26. Article 26, of course, is the provision requiring performance of treaties in good faith. We get another reference to reasonableness at 1200, 2.4.2, good faith meaning reasonableness. There's a reference to the Nicaragua judgment of the ICJ, and then read in the same spirit of analogy.
Now got behind, I'm sorry.
Oh, I'm sorry, Manol, page 1200 of the bundle, page 176 of the text. You should find 2.4.2, good faith meaning reasonableness. And then after the citation of Nicaragua against the United States, read in the same spirit of analogy, this bears out the suggestion that one component of good faith in interpretation is reasonableness. Then 1203, under the heading 2.4.5, for the relationship between a good faith interpretation and the question of object and purpose and the principle of effectiveness. And the ILC stating, when a treaty is open to two interpretations, one of which does and the other does not enable the treaty to have appropriate effects, good faith and the objects and purposes of the treaty demand that the former interpretation should be adopted. And this, of course, all feeds in to what we submit to be the particularly important observations that the judge made at paragraph 116 of his judgment, which I'll return to. We respectfully submit that India's approach to interpretation, seeking to limit the investor-state arbitral offer in the way that it does, and limiting the notion of direct application to action, even in a context such as this, to action taken against essentially the shareholding certificate, or to be a bit more generous, perhaps the voting rights associated with the shareholding, and so forth, involves at best the literal dogmatism that the principle of good faith rules out in this very specific international investment treaty context.
It draws a distinction. If you have an investment in money, if that's then converted into shareholding, and even if you have directors on the board, etc., control the company, or have a say in, they would say that's not direct effect. But if the investment is effected by way of a partnership, so you're a partner in the business, then presumably it would be different.
Yes, they would say that.
But there's nothing in the treaty which suggests that direct application should depend upon the manner in which the investment is held, whether it's converted from cash into shares or converted from cash into a partnership share.
No, my lord. What matters, we say, for direct application is, as I say, I'll come to the particular other treaty context provisions which support us. But what matters at a first stage of good faith ordinary meaning is this action, in this context, action applied directly to this shareholding, to this asset as invested? The judge held it was, and he was quite right to do so, having set out in detail the particular factual context he did, and having made the very particular point, undoubtedly correct, to distinguish between the ownership of a simple shareholding and the ownership of a shareholding which was the whole modality by which investment was made and a project got off the ground. They're in the end two sides of the same coin. The direct application to one is direct application to the other.
Well, the term is direct application
to the investment.
To an investment,
yes,
isn't it?
Yes.
And it's true that the various limbs of what's an asset include things like shares, but in the end, as a matter of language, the question is whether it's directly applied to an investment.
Exactly, my lord, and we say that supports us. It's not direct application to an asset or direct application specifically against a share, as India would have it at paragraph 65 of its skeleton. It's viewed from the international plane in an investment treaty context, as a matter of ordinary meaning, direct application to the investment. And it's obviously perilous and becomes slightly self-serving to make a submission like this, but I'll have a go nevertheless. If one asks on any sensible view, when the two states are negotiating about a treaty to promote and protect investment, and where the two states are promising to encourage incorporation of companies in each other's jurisdiction, if one asks the question, well, if you go down that route, if you incorporate a company, if you hold shares in that company, and then we, the host state, completely undercut the whole raison d'etre for the project, for which your shareholding was the modality of getting it off the ground, is that applied directly to the shareholding? Of course it is, we say.
The judge seems to identify three categories of action in his paragraphs 111 and 112.
Yes.
One is action which is targeted at the investment.
Yes.
Another is an action which is directed or targeted elsewhere, but which has collateral, what he calls collateral effects. And a third is measures of general application that have an adverse effect on the investment, but also on other assets.
Yes.
Is that a helpful division? Is that a test which you support or not?
Well, he identifies those different categories. I'm not sure, to be fair to him, he puts a very hard line between each category. And even in the third category, he says the position may be different.
Yes, he does.
May be different with measures. I'll come, if I may, to those particular passages in the judgment.
Yes, all right.
But our basic point on it is that what he is saying is that if you've got a targeted measure, that is definitely sufficient to be applied directly. And that's really as far as I need to go. I don't need to get in. And he acknowledges later in the judgment, I think it's paragraph 115, it may be difficult sometimes to work out where the line is. But where you've got a targeted measure, targeted action, directed only at one particular project with which the shareholding is entirely bound up, it's not a difficult question. But I'll come to exactly how he puts it and what we say in response in sequence, if I may. So, as I say, the judge at paragraph 100 concludes that it's clear enough that GOM 44 is binding action attributable to India. And as we've seen, there's no challenge to that finding. He also finds at paragraph 101 that that was action taken under a law, rule or regulation. And so he ticks that box too in terms of the definition of Article 1.8. And so the only question left for him and for your lordships is this question of whether that binding executive action was properly characterised as applied directly to the investment. And it's that he then deals with at paragraphs 102 through to 117. At 102, he sets out the tribunal's finding as to what the executive acts identified were directly applied to. At 103, and this is, we say, important, it's a point I've already made in answer to some of the questions, but to anchor it in a reference in the judgment, he said that it helped to keep in mind that RAKIA's investment was not simply a shareholding, picking up on the point he'd already made at 93, and saying that over time it was a number of things and so on, and that these were invested in the proposed establishment of the industry in Andhra Pradesh. And those observations were, we say, both important in understanding the judge's approach and entirely apt. He was emphasising, in line with the treaty, that what mattered, as my Lord Justice Miles has just pointed out, what mattered was whether an asset was invested. And he was drawing that distinction between a pure share purchase and shareholding, and acquisition, holding and investment. He was emphasising again that these shares, these particular shares on these facts, did have that quality of investment because of their very specific role in the furtherance of a specific and identifiable project in Andhra Pradesh. And that was accurate as a point of factual distinction and entirely legitimate, we say, as a matter to emphasise in the task of interpretation and application to the facts that the judge was by this point engaged on. At 104, he sets out what was the beginning and the end of the tribunal's analysis of this issue, that the acts in question merely had an indirect effect on the shareholding, and that was not enough. Now, we, of course, don't accept that characterisation, or the rather conclusory approach, and nor did the judge. It didn't, we say, adequately reflect the factual context referenced in 103, and the effect on this shareholding was immediate, inevitable, and destructive of value. So it was, on any reasonable view, we say, direct in its application. Now, going on with the judge's judgment, he then expressly rejects the tribunal's analysis at 105 as appropriate to this treaty and this case. And his reasoning in the paragraphs that then follow, we characterise as having 6 stages. The first at 106 was to explain that the tribunal's view reflected the familiar principle that, generally speaking, a loss caused to a company was not to be treated as a loss caused to shareholders when the question is who has standing to sue. And he said the tribunal's analysis recognised the principle of separate corporate personality. And he noted that that principle respected the common law rule against claims for reflective loss, and he noticed India's reliance before him, repeated before this court, on the ICJ's Barcelona traction decision relating to diplomatic protection. So that's stage 1, where he analyses what the tribunal, he thinks, has been doing.
Is that actually what the tribunal did?
It's actually very difficult to see, my lord, beyond...
I'm not sure, for my own part, that the tribunal was making the reflective loss point.
It's rather difficult to see, my lord, we would respectfully submit, because you get very little in terms of articulated reasoning from the tribunal on why it's reaching the conclusion it did, beyond the indirect effect conclusory statement that I referred to.
I mean, reflective loss is very difficult to see in this context because there isn't a cause of action by the company.
No.
Reflective loss arises where both the company and the shareholders have a claim. And the question is whether in those circumstances, the shareholders can bring an action. Whereas here, as I see it, ANRAK wouldn't itself have the same claim, and it might have a claim for repudiation of the contract.
Yes.
But it doesn't have a claim against the government of India.
No, it doesn't have a claim under the treaty, my lord. But
So it'd have a claim against someone else. But reflective loss applies where you've got two claims against the same defendant.
Well, it might have a claim against the government of India, but in India, relating to its allegedly unlawful decision to issue GOM 44.
Well,
but that
conceivably, but if it's a lawful, if GOM 44 is lawful,
well,
it may very well not have any claim. I mean, all I'm saying is that I'm not convinced that the judge has said that the tribunal went wrong here by applying reflective loss principles. I'm not sure that's what they were doing. I think they were just saying, we don't think it's within the meaning of the wording a measure which directly applies to the investment.
Well, it's certainly saying that, my lord, and it's saying by reference to 137 that indirect effect isn't enough. It doesn't refer to Barcelona traction, but what it is doing, we would say, by referencing that notion of indirect effect, it is in a sense bringing in this concept of separate corporate personality and separate ownership.
Possibly.
In any event, whether the tribunal was...
They accept, or at any rate they assume, that the action diminished the value of RAKIA's shares.
Yes.
But they say that is an indirect
That's
effect,
an indirect
not a
effect.
direct one.
Yes. So, but what was right about what the judge did, whether he was wrong to criticise the tribunal in the terms he did, is one question. But the important question is perhaps whether he was right to take an international law view approach and an investment treaty law approach. And you certainly had Barcelona traction cited to you in support of the proposition of separate corporate personality to bolster India's case on applied directly in this appeal. And that is a flawed approach because the principles of diplomatic protection simply are not to be read across to the investment treaty context where the lex specialis is the treaty. And armed with the Vienna Convention, off you go. So
that all seems like a bit like a red herring to me.
Maybe a bit of a red herring, but it's in terms of criticising the tribunal, but not a red herring in terms of the appropriate starting point for the exercise of interpretation under the Vienna Convention and applied directly. We certainly agree the whole notion of Barcelona traction, separate corporate personality in that regard is a red herring for the reasons we've explained at paragraph 17 of our skeleton.
It's very, at the end of the day, it's a very simple question, isn't it? Which is that does the wording in 1.8 apply directly entail that government actions affecting the business of the company is not applied directly to the shareholders of the company? That's the simple question.
That's the
only question we have.
Yes,
here.
And the answer...
You go round and round in circles looking at it, but at the end of the day, it's a simple question of is that the right interpretation or not? And there are various clues, it seems to me, in the treaty itself as to the answer.
Yes. And the only rider to that, my lord, it's does the action of the government of India in this case, in this particular factual context, apply directly to this shareholding? That's the ultimate.
That might be the ultimate question, but it's a fairly general question, isn't it? Because the reason it does or it doesn't is whether or not this treaty, the reference to apply directly in this treaty, means apply that it is that a government action doesn't apply directly to an investment held qua minority shareholder?
Yes,
that's the only question.
That's the only question. But in answering it, we say the court also has to have in mind the factual context, because you might be in a position where you say, in answering that question, it depends. It can apply directly to a minority shareholding. And on the facts of this case, it does, we would submit, apply directly to this minority shareholding because of all the factual points I made earlier.
But first of all, presumably, you make the more general point is that it would, as a matter of interpretation,
yes,
generally.
Yes. As a matter of interpretation generally, it's certainly capable of applying, and we say on a natural, ordinary meaning does. And when you look at 3.2, 7.1, preamble, 7.3, 7.4, those are all clues, we say, pointing in the same direction. So the second stage of the judge's approach was you need to take the investment treaty lens and recognise that Barcelona Traction doesn't have any application here. Third stage is at 108. The judge is correctly identifying that the search is not merely for an asset, my Lord Lord Justice Miles' point, not merely for an asset to which some relevant executive action has been applied directly, but for an asset as an investment to which the action has been applied directly. Fourth point, the judge identifying again the material question really, as my Lord's just put to me. The material question is simply what has been applied to the investment. So here the shareholding as invested in the project, as opposed to what's done with only an indirect or no application. And then 110, his conclusion that what was his acceptance that what was necessary was both applied to the investment and direct application. And then his conclusion at 110 that both those elements are satisfied. And then he explains why in the paragraphs which follow. And at 111, which we've already seen for the purposes of ground one, but is obviously absolutely central, he is saying there was application to the investment in that, or as we would say, because the binding action was applied to the alumina and aluminium project. And he then explains in the next sentence that India had acted directly to end the bauxite supply integral to the whole project. Now, there was nothing wrong with that analysis, we say. It was entirely reasonable, entirely in line with ordinary meaning, entirely in line with commercial common sense, having regard to the factual context we've looked at and which the judge had set out. On any view, as I've submitted, the binding action was applied directly to the BSA and to the project. It was ending or altering the BSA, and it was removing the cornerstone of the project as originally envisaged in all of the foundational and implementing documents, whether MOU, BSA or shareholders agreement, the exclusive supply of local bauxite. So that in turn meant, and this is why we say perhaps you do get some assistance from the passages in Gardner that I showed you, that in turn meant that in the particular circumstances of this case, on any good faith, reasonable, non-dogmatic interpretation of the term applied directly, that action was also action applied directly to RAKIA's investment, its shareholding in ANRAK as invested in the project. And it doesn't make any difference that that was a minority as opposed to a majority shareholding. The shareholding had only come into being as an asset invested because of its inextricable link to the project with its promise of local bauxite supply. That's the critical factor, not minority or majority. And there was, we say, an inevitable and direct application to the investment because of that impossibility of separating shareholding as invested from the project. And so focusing again on the particular words used by the judge in paragraph 111, before doing that, I should perhaps give the court another reference to GOM 44 itself, because GOM 44 itself also illustrates this inevitable link between project, local bauxite supply and shareholding, because it references the local bauxite, it references the MOU, it references the obligation of supply of local bauxite and the incorporation of RAKIA's shareholding in ANRAK. And that's SB 329. So, going back to the judgment, focusing on the particular words used by the judge in paragraph 111, the application to the shareholding was direct both because of the nature of the project and that inseparability, as I characterise it, from the investment, and because by GOM 44 the cornerstone of the whole project had been removed. And we say the judge was entirely correct, as we put it at paragraph 38.1 of our skeleton, to reference the project in this context, because what was necessary under the terms of the treaty was not merely, again my Lord's point, not merely direct application to an asset, but direct application to an investment, the shareholding qua investment. Now, paragraph 112, the judge elaborated further on the question of directly and that sub-element, and he made three further points as to why he considered that it was satisfied in the present context. First, he said this was not a case of action directed elsewhere, but happening to have adverse collateral effects on the shareholding qua investment. That's the first sentence. Secondly, he accepted that measures were correctly characterised as applied directly to an investment if they were targeted at an investment. That's the second sentence. And thirdly, he acknowledged, and this is the tripartite characterisation that my Lord put to me, he acknowledges in the third sentence that the position might be different with measures of wider general application that might or did have an adverse effect both on an investment and on other assets invested elsewhere. But that was, of course, not this case. The only assets affected here were those bound up with this very project. And so to the extent that they were investments, we say the measure simply had to be treated as directly applied to them, and the judge was right to so hold. And that reasoning of his was, with respect, entirely correct. Now, it's perhaps important to emphasise in this context of targeting that we don't need to say targeting is necessary in all cases. We simply say, and this is I think paragraph 27 of our skeleton argument, where targeting is present, it's sufficient. And that's entirely unsurprising. Now, paragraphs 113 to 117 of his judgment, the judge then addresses three further matters which supported his conclusion. And it's in the context of addressing these that I'll also address, if I may, the individual treaty clues that we get as to the right outcome in this case. First of all, paragraphs 113 to 115 of his judgment, the judge emphasised that his approach involved a balance. At 113, he spoke of the result of his analysis being a balance recognising that it was likely to be more readily justifiable to extend an arbitral offer in respect of executive action that did not itself apply more widely than it would be where wider executive action might be inhibited. And again, there was nothing wrong with that as a matter of policy or principle. At 114, he then referenced India's observations about the right to regulate and its assertions that this did not assist with the particular interpretive exercise in play. But he stated instead that it was legitimate to ask why the treaty introduced the concept of directness. And his answer, evident we say from his approach in the preceding paragraphs, was the balance that meant that targeted or narrow action would definitely be caught, but that wider, more general action, having only collateral effect, might not be. And similarly, in the first two sentences of paragraph 115, he recognises that this difference between executive action that didn't apply more widely and wider executive action introduced in his judgment at 113 might not always be straightforward to identify, but he felt it to be possible and that it flowed from the choice of the word directly. And again, there's nothing wrong with that. He's indicating the line may be hard to draw in some cases, but it's not hard to draw in this case. Now, the second additional matter...
I suppose that to say that applied directly may sometimes apply to wider executive action doesn't mean that the state can't carry out such wider executive action. It simply means that a complaint about it is arbitrable, although it may fail on the merits because what the state has done is perfectly lawful.
Yes, it may come in again at the merits.
Yeah. Okay.
Now, the second additional matter addressed by the judge in the remainder of 115 was to reject India's argument that either Article 7.4 or Article 14.2 of the treaty presented any obstacle to this analysis. And he considered instead that their working was not affected by an appreciation that to be a measure as defined, an action would be targeted, that is, directed. And he also held that Article 14.2 could be characterised as a for the avoidance of doubt provision. And we respectfully submit each of those points was entirely correct. And it's against that background that I'll go to the treaty, if I may, and pick up on both of those points, but also on the other aspects of the treaty, which we say support the landing point that the judge arrived at and the interpretation as to applied directly that we contend for. And the court, of course, has this treaty at page 138 of the bundle. And just before we get to 7.4, on the way, I'll pick up, if I may, the preambles, the desire to create conditions favourable for fostering greater investment by investors of one contracting party in the territory of the other contracting party. The next preamble, recognising that the encouragement and reciprocal protection of such investment made in accordance with the laws and regulation of the host contracting party will be conducive to the stimulation of individual business initiative, will increase prosperity. The express reference to shareholding in the list of assets as invested that you get in 1.12 on pages 138 and 39. The important provision, again underscoring the importance of the shareholding context in Article 3.2 on page 141, the contracting parties shall encourage and facilitate the formation and establishment of appropriate legal entities by investors in order to establish, develop and execute investment projects in different economic sectors, as may be permitted by the laws and regulations of the host contracting party. So putting centre stage, really, the point that the judge makes at 116 of his judgment, that we'll come back to, about major forms of investment structure. And then we get to Article 7, and I'll deal with 7.4 first. This is the judge, to support the judge's conclusion that it's perfectly workable, even if you introduce a concept of targeting or direction at. And if you have it, it's page 145, and of course it uses the term measure. but to give measure the longhand interpretation contemplated by the judge, and to introduce the notions of targeting or direction at, it would read: the term expropriation shall also apply to interventions or regulatory actions by a contracting party targeted or directed at an investment, such as the freezing and so forth. And that would be entirely workable in practice. And India's argument proceeds on the basis instead that regulatory action could not by definition ever be targeted. But that is, we respectfully submit not so. And the examples actually given in 7.4 are all readily capable of being characterised as targeted actions: freezing or blocking of investments, compulsory sale and so forth. Now, Mr. Dar returned to Article 7.4 yesterday to make a different point in relation to it, rather than the point I've just been making to defend the judge's conclusion. And he said that Article 7.4 assisted India on treaty context by showing the kind of action a measure was concerned with, and by drawing a distinction between the nature of an action, that is, a measure, and its effect on the value of an investment. And we respectfully submit that neither point is a good one, and that, in fact, read properly, Article 7.4 supports RAKIA, not India's, approach to applied directly. Now, as to the first of those points, the examples of measures given in 7.4 are just that. They're examples. They don't purport to be exhaustive, and they are, as I've said, if anything, illustrations of targeted action. And as to the second point, we say that the remainder of Article 7.4 is directly inconsistent with India's narrow approach to the meaning of measure and the words applied directly. And that is so, we say, because of its use of the term measure in the fourth line, measures in the fourth line of 7.4, and the series of disjunctive scenarios set out in the last four lines that Article 7.4 contemplates a measure could involve. Because if you read those last four lines, you'll see that that wording is expressly contemplating that a measure might be something which leaves an investor in full ownership and control of its investment, or the substantial benefits over the investment, but which still results in total or near total loss or damage to its economic value. So to give the example of a shareholding as the form of investment, it's expressly contemplating that a measure may be something which leaves ownership and control and substantial benefits associated with that shareholding, whether dividend entitlements or voting rights and the like, untouched, but which severely damages its economic value. And to give measure its full definition, that is therefore in turn contemplating that binding action can be applied directly to a shareholding, even if it leaves ownership and control and benefits of that shareholding untouched, but has a severely damaging impact on the shareholding's value. Now that was RAKIA's case as to what had occurred here, and it's entirely in line with its approach to the meaning of applied directly. And so we say, far from assisting India, 7.4 is a clear indication favouring RAKIA's approach to applied directly. And this case is the clearest possible instance of such a scenario. So 7.4's, as I say, use of the term measures and contemplation of measures applying in a context where ownership, control and so forth is untouched, but value is destroyed, is directly supportive of our approach to Article 1.8 and the meaning of applied directly. So too is the interrelationship between 7.1 and 7.3 in Article 7. Now, starting with Article 7.3, it's made clear that the treaty here is expressly contemplating claims for reflective loss as being available under the BIT. It is requiring in terms fair and equitable compensation in respect of a shareholding investment as a result of expropriation of the assets of the company in which shares are held. So that is exactly a reflective loss scenario.
I don't think it is.
I don't think it is either.
I think it's making a more basic point, which is that the treaty treats as an expropriation the taking the assets of the company, and a shareholder can complain about it. I don't think that's a reflective loss point. Sorry, it may be a quibble.
Well, if it's
but it's not really about reflective loss. It's extending what's meant by expropriation, and it might be said it's extending it for the avoidance of doubt.
It might be. Perhaps I can put it at a higher level and think about whether I need to push back on whether it's any more than a quibble, if I may, my lord. But what it is clearly contemplating is that where the assets of the underlying company are expropriated, there will be an entitlement on the part of the shareholder to compensation to reflect the value of the investment. And what it's also doing is it's then saying, in that scenario, which is what we say is the scenario here, subject to our Respondent's Notice Ground 1, where the assets of the underlying company have on any view been damaged, it's then cross-referencing to 7.1, because it says the contracting party shall ensure that the provisions of Clause 1 of this article are applied to the extent necessary to ensure fair and equitable compensation and so forth. Now, the first point I make, which is at least subject to thinking further about the quibble point, consistent with the grain of interpretation that we would urge on the court in respect of Article 1.8 and applied directly, is it's certainly contemplating that there will be a right to compensation for the ultimate shareholder. And that a reasonable interpretation, my Gardner point, would therefore feed in, informed by 7.3, to the approach to 1.8. But on the cross-referencing point, so there's an obvious tension, we say, between interpretation of a treaty which on the one hand, by Article 3.2 is expressly encouraging incorporation of local entities, and by Article 7.3 is identifying an entitlement to compensation on the part of the shareholder. There's an inherent tension with that on the one hand position, and on the other hand, on India's interpretation of applied directly, saying, but there's still no arbitral redress through the investor state route. But as I say, the point goes further because of the cross-referencing. We say that Article 7.3 is requiring the application of Article 7.1 to the fact pattern it describes. And whether it's accurate to describe it as reflective loss or not doesn't really matter. The fact pattern it describes is a right to compensation as a result of action taken against the underlying asset. And then Article 7.1a in turn protects investments from nationalisation, expropriation, dispossession, or subjection to direct or indirect measures having equivalent effect, all of which are then collectively defined as expropriation, and all of which are described in the third to last line as measures. So, reading the two together, 7.3 and 7.1 together, we say they're expressly contemplating that a measure can exist in relation to an investment in the form of shares in a local company, where what the measure is doing is expropriating the assets of the local company. The fact pattern just described in 7.3. Or to use the longhand definition of measure in 1.8, they're contemplating that a measure, binding action, can be held to be applied directly to the shares by virtue of the expropriation of the local company's assets. And so that too is entirely consistent with what we submit to be the ordinary, reasonable, non-dogmatic meaning of applied directly. And it's quite inconsistent with India's approach. So much for Article 7. The judge focused only on 7.4 for the purposes of saying it's workable even on my approach. We say he was right. And the further detail in respect of it further supports RAKIA, we say. The judge also, we say, was quite correct to say Article 14.2 was workable on his approach. And your lordships have 14.2 at page 152 and 153 of the bundle. And it too, we say, can easily be read with the concept of targeting or direction introduced to replace the word measures. On that basis, it would read as follows. Nothing in this agreement precludes the host contracting party from taking necessary, reasonable, and then in place of measures, action targeted or directed at an investment in accordance with its laws applied generally on a non-discriminatory basis in circumstances of extreme emergency, etc. And we would respectfully agree with the observation made by my Lord Justice Phillips yesterday when this provision came up, that what this clause is doing is making it clear that nothing prevents the contracting party from taking reasonable action in accordance with its laws applied generally and so forth. So the words applied generally apply to the host state's laws, not to the measures themselves. So again, nothing unworkable about 14.2. And finally on this point, the judge was also, we say, quite entitled to see this provision as a for the avoidance of doubt provision, included to make a provision explicit in terms of the availability of a merits defence in a particular emergency context. It doesn't tell us anything about the meaning of the term applied directly, or whether, as we would contend to be the case, targeting would necessarily must satisfy that test.
May I ask, I've looked, we only have extracts from the pleadings, the statement of case in the arbitration.
Yes, my lord.
Relating to the jurisdiction issue.
Yes.
And I see that the tribunal said that RAKIA alleges a number of breaches of the BIT. Can you say which articles do you allege were breached? Do you allege Article 7 is breached?
Yes, my lord, we did and we would.
You did?
Yes.
Yeah. What about which other articles?
I'll come back to you and give you a 100% accurate answer if I may. From recollection, we also relied on fair and equitable treatment in particular. But can I give
you say that GOM 44 was an expropriation?
We said it was, my lord,
Relying on 7?
Yes, because what it was doing was destroying the value. So those were the first two additional matters that, going back to his judgment, that the judge had identified as supporting his approach. Balance and regulation and so forth, and saying that he didn't think much of India's points on 7.4 and 14.2. And then the third additional matter is the one that I've emphasised, and the one he addressed at paragraph 116 as particularly relevant. And we say it's particularly relevant to questions of both good faith and object and purpose. And it concerned, as the judge described it, the practical consequences of the rival contentions as to how the term applied directly was to be interpreted. And the judge concluded that the tribunal's approach favoured by India would in practice involve taking we would say perhaps the major form of investment structure, a shareholding in a local company, outside, and to give it its full meaning, as my lord put to me, outside the compass of the arbitral offer of the BIT to investors without any apparent rationale. And that would in turn give rise to the very odd outcome that the judge referenced in the second sentence of paragraph 116, namely that investors would be advised to avoid investments that took the form of establishment of and shareholdings in local companies. And the judge was right, we say, to see that as a very odd conclusion or landing point. And that is made very clear, if it weren't clear as a matter of instinct, made very clear once one looks at the treaty itself in terms of treaty context and the treaty itself in terms of object and purpose. It would run counter, we say, to the stated desire that I showed your lordships in the preambles to foster greater investment and the importance of protection of such investment. It would run counter to the express identification of shareholdings as invested, as protected investments in Article 1.2. It would run counter to the very specific provision in Article 3.2 of the treaty, by which the state parties specifically bound themselves to encourage the establishment of local entities to further investment projects, precisely what occurred with ANRAK. And it would run counter to what we say is the correct interpretation of Articles 7.1, 7.3 and 7.4, each of them contemplating a right to compensation for the shareholder where the underlying assets of the company are, on any view, directly impacted. Now, each of those features, we say, are positive clues in our favour as to the meaning of applied directly. There were a number of other provisions raised yesterday by Mr. Dar, which I should come to, if I may, in this context. The first was, in sequence within the treaty, was Article 2.1 and 2.2. I've just been handed a very helpful note before I get to that to answer my Lord Justice Phillips' question before I forget to answer it. In the arbitration, it was claimed there had been a breach of Article 3, the encouragement provision. It was claimed there had been a breach of Article 4, the full protection provision. It was claimed there had been a breach of Article 5, fair and equal treatment. And it was claimed there had been a breach of Article 7, expropriation. So back to the treaty. Article 2.1 and 2.2 were referenced yesterday as somehow assisting, as we understood it, because they showed a desire for certainty in terms of temporal application which would be ill-served by the fact-sensitive approach adopted by the judge and contended for by RAKIA. We respectfully submit neither provision assists India. As to Article 2.1, that is, if anything, helpful to RAKIA because it shows that temporal jurisdiction is not dependent on the existence or otherwise of a measure at all. Because we know that some substantive provisions of the treaty to which it would necessarily apply do not need themselves to involve a measure at all. And the example given yesterday was Article 5.1 and the fair and equal treatment obligation. Now that may well in many cases involve measures, but it doesn't on its face have to do so. There's the further point that the fact that the temporal issue to be determined in any given case might involve a fact-sensitive inquiry to determine jurisdiction is not in itself objectionable. That just follows from the treaty. And Article 2.2, as we say, is simply neutral. It tells you that if a measure is consented to, it is taken outside the scope of the treaty, but it doesn't help you determine what a measure is. And so to take the example in this case, in a different world, ANRAK might have been offered compensation in return for the cancellation of the BSA. Or RAKIA might have been offered compensation in return for the cancellation of the BSA, and so be said to have consented to it. But that doesn't mean that the cancellation would not be a measure in any meaningful sense. Like the other three other provisions Mr. Dar referenced yesterday, which again we respectfully submit don't advance his position at all and don't assist at all on the meaning of applied directly. The first was 5.3 and the exclusion of jurisdictional matters from the most favoured nation provision. And the second was Article 10.2 itself, with the insulation from at least some legislative measures and all judicial measures, as India would have the interpretation of that clause. But neither of them assist on applied directly at all. Article 5.3, as we've heard, might well have been simply a response to the well-known controversy as to the appropriate use of most favoured nations clauses in a jurisdictional context. But that doesn't tell you anything about what applied directly means. And likewise, Article 10.2 is at most telling you something about insulation of judicial and legislative measures from an arbitral protection, but it doesn't tell you anything about the position in respect of executive action or anything about how an undefined term applied directly is to be interpreted. And I think the last provision referenced was Article 10.8b, the limitation provision, and that was said to be an example of the treaty distinguishing between measures and loss and damage caused by such measures. And as to that, we say simply that there's nothing unusual about a limitation provision focusing on both action and knowledge of loss and damage. But that too simply doesn't assist on the meaning of applied directly, and whether in an appropriate case, once the facts are properly confronted, applied directly can be satisfied by the impact of action on the value of an investment. So the key point made by the judge at paragraph 116 remains, we say, entirely unanswered, that on India's approach, the parties would, on the one hand, and in line with a treaty designed to promote and protect investment, be obliged to encourage a specific form of investment. And then on the other hand, and for no apparent reason, be very substantially depriving the investor of an arbitral offer so as to be able to enforce protection of that investment. And that is simply not, we say, where a good faith interpretation in line with context or object and purpose should lead. And it's no answer in this context. This is the point I gave a preliminary answer to my Lord Justice Mayles earlier. It's no answer in this context to say, well, there's often a disjunct between some substantive protections and arbitral protections. We would accept that such a disjunct is not unheard of. Russia and China, for example, have historically shown a particular lack of enthusiasm for arbitral protections in the treaties they enter into. But the important point is that where there is such a disjunct, where there is such an exclusion, it is achieved by clear words. It's not done by what we submit to be an unnatural, uncommercial, and unpurposive interpretation of undefined terms, such as applied directly. And as I said earlier, the case cited yesterday in this regard was EAIB, tab 12, page 175, paragraph 385. And the point made by the tribunal there was the very simple one, that object and purpose considerations cannot prevail over the clear meaning of words used to exclude jurisdiction. And in that case, those clear words had clearly and expressly limited the scope of the jurisdictional offer and confined it to questions of amount of compensation. And the problem for India here is that there are no such clear words. And as I said earlier, it's asking instead the undefined, on its case entirely unprecedented words applied directly, to do some very heavy, unreasonable and uncommercial lifting. And in this regard, we do respectfully adopt the force of the hypotheticals that were put to Mr. Wordsworth and Mr. Dar yesterday, and the object and purpose challenges of looking simply at a piece of paper, whether it be a loan note, whether it be a share certificate, in determining what was or was not applied directly to an investment as a matter of ordinary meaning in this international investment treaty context and common sense. Now, as we understood the response yesterday to those hypotheticals and to that problem, as the judge had identified it, the response was essentially, so what? That's what the treaty says. The words "so what" were used. Secondly, it was said, well, Article 1.8 is very unusual. And thirdly, this is why we spent about half an hour on it, one shouldn't ignore the white industries context as explaining why this may have been done. Well, as to those points, my lords, it's obvious, we say, what the answers are. The so what answer is, of course, a circular bootstraps argument. It assumes the conclusion in aid of its proof. The Article 1.8 is jolly unusual argument. The response to that is, well, it would be jolly unusual if it operated in the way India contends that it's to operate. But there's no logic or reason why it should do so. And the white industries point, as I've already said in opening our response to this appeal, aside from evidencing, at best, unilateral and very generalised concerns and intentions on India's part, and so being inadmissible under the Vienna Convention, the white industries context told us absolutely nothing about what was intended or meant by the term applied directly.
Well, the answer to that you could give to that is, so what? You could give to that argument.
I could, my lord, yes. all the white, even assuming white industries to be properly before you, notwithstanding the unilateral problem.
It seemed to me there was a certain inconsistency in the approach.
Yes.
The appellants, that when it suited them, they said, well, the words mean what they say.
Yes, my lord.
When it didn't suit them, they said, well, look at all this background.
Yes. I'd like to characterise my submissions as having a bit more substance, though, than so what, my lord, if I may, without deluding myself. And the point we emphasise, as a matter of substance on white industries, you looked at what it showed. It showed India didn't like losing arbitrations. It showed perhaps India had a particular sensitivity about its judiciary being subjected to complaints in international arbitrations. But it's just a ship passing in the night as far as the interpretation of applied directly is concerned. It doesn't assist at all. So there remains no answer to that problem the judge rightly identified in this investment treaty context. Now, it's true also, there was one further point that's made in response to this problem, and what we say is the instinctively and Vienna Convention informed problem of India's proposed landing point. And the answer was, oh, well, don't worry, the state-to-state arbitration. Article 11 is the panacea here. Now, Article 11 allows on its terms for disputes as to interpretation, execution or application to be raised by one state with the other. But by definition, as was pointed out yesterday, it is not available to be instigated by a shareholder investor when the assets of the company through which it has invested are prejudiced or taken. And it is a process which, even if instigated, is a process over which the investor has no control whatsoever. State-to-state arbitration...
I suppose where the investor is a state-owned company closely associated with the government of its state, it may in practice have a bit more of more clout with the government than...
Yes, in practice it may, my lord. Although it's important to remember RAKIA is the investment authority of one emirate, of I think it's 7 emirates, I'll be corrected if I'm wrong. And so it's not simply the UAE's investment authority.
But also that can't affect the interpretation.
No, it's just a factual point of response. Yes. So it doesn't affect interpretation. The key point on interpretation is that the existence of an entirely standard state-to-state arbitration clause is no answer to the problem presented for the investor, because it can only be instigated by a state, it's controlled by a state, the state's decision-making may be influenced by a whole range of diplomatic or political considerations that have nothing to do with the investment. And it's no answer to the poor investor, as we would characterise them, who have been encouraged specifically to incorporate in the host state, and is confronted with a treaty contemplating compensation being available in the Article 7 context, where there's expropriation of assets of the underlying company. It's no comfort to the investor to be told, oh, well, the state could take up your cause. It is a very poor cousin in terms of effective enforcement, because of that fact that it's in the discretion of the home state at every turn. And that is borne out by the fact that instances of its use are so rare. So far as we are aware, it has never been used by either India or the UAE at all, let alone as a vehicle for obtaining compensation for investors. The reality is exactly as it was put by my Lord Justice Mayles, that the availability of state-to-state arbitration as a matter of theory may well leave an investor high and dry and without a remedy. Now, we wouldn't go as far, and I don't submit, as to say that as a matter of legal theory, it is impossible to pursue compensation under a state-to-state arbitral process. We are not aware of one ever having been used for that purpose, and Mr. Dar hasn't pointed to one. And there's simply no explanation, we say, as to why on the one hand, India and the UAE would take this particular approach, allowing on India's case for a state-to-state arbitral process to protect shareholder investments in respect of executive action, but not allowing for an investor-state process because of the particular magic that India attaches to the words applied directly.
Is there anything in that passage you showed us from, I don't know whether it's Professor Gardner or Mr. Gardner's book, where there was a passage concerned with the effect, I'm going to just call it this for shorthand, some principle of effectiveness within the meaning of good faith. But one of the passages you showed us talked about the principle of giving a treaty an effective interpretation.
Yes,
does that come in under this part of the argument?
Under the state-to-state aspect of the
under the idea that one might think that if there's in general terms, subject to clear wording, if there's a right for investors, you might think they might have a remedy.
Yes, it does, we say, my lord. And it's, and I don't put it too high because it's clear that if there are clear words which are excluding that remedy, there can be a disjunct. But all of this, that's why I emphasised Gardner at the outset, all of this is consistent with the grain of RAKIA's case, not with India's. And so we respectfully submit that, viewed in that way, the judge was right for the reasons he gave, and there is really nothing of substance in India's criticisms of it. And instead, we say that each component of the Vienna Convention on the Law of Treaties supports us. You have what we submit to be correct instinctive starting point as to ordinary meaning. You have good faith interpretation favouring reasonableness, effectiveness, and so forth. You have treaty context provided by the preambles, by Article 1, by Article 3, by Article 7. And you have object and purpose of the treaty as illustrated by, again, the preambles. All of that consistent with the landing point the judge arrived at, and very difficult to reconcile with India's landing point, absent the very clear words. And that's why I keep saying, applied directly, are doing a pretty Herculean task on India's case. My lord, that leaves me only with, I think, about 2 minutes on Respondent's Notice Ground 2, because I've covered, I think, a lot of the ground within it in talking about impact on value.
All right.
And I'm in your hands as to whether I continue that now or do it after.
Well, we'll have those 2 minutes at 2 o'clock on the basis that they won't expand over the next hour.
Thank you.
2 o'clock.
Court rises, evening.